All right. Hi, everyone. So last week I said to send me an email if you thought there was something that you felt you hadn't been trained in debating this year that you'd really like us to have a chat about. And I've gotten a few, so I've got some things that I can talk about over the next couple of weeks. And this week, as you can see, we're going to talk about criminal justice and debating, because that was kind of a common theme in the emails I got. But particularly for those of you who are new to debating, these couple of weeks towards the end of semester 2, well, middle of semester 2, are kind of the times that you get the most say over what training needs to be done. There's no stylistical things we still need to teach you. We've taught you how to do the basic elements of debating. We've kind of taught you tactics, and really the main things you're going to improve on in that aspect will come from practice. This is really an opportunity for you to ask and say, look, I did this debate on the Middle East the other week, and I had zero idea what I was supposed to be talking about, and it was an absolute disaster, and therefore I'd like some feedback on how to do that better. And chances are, if you're thinking it and having trouble with it, lots of other people are too. So I just want to start off by saying, send me an email at any point. The email is just the same one as always, training@monash-debaters, and that way I can incorporate that into sessions over the next couple of weeks for you. In terms of what we're going to talk about today, I want to take you through a little bit of kind of the basics of criminal justice, and for those of you who've been around debating a bit longer, this part of it will be a little bit boring. But we're going to talk a little bit as well about how you can conceptualize actors within criminal justice debates and how you can talk about accountability and efficiency and concepts that perhaps don't get applied to criminal justice debates as often as they perhaps should be. And we'll try and break some of that down. The final thing I want to talk about in this session, I'll talk about it towards the end. Can I get a show of hands? Who here in the room is a law student? Yep. Who here is not a law student? Of those people who are not law students, how many times have you had law students in debates use terminology and you had no idea what it meant? Or that was an issue in the debate? Yeah? It's probably more of an issue as you get into more advanced debates, but terms like negligence are really technical terms from a legal perspective, but are often used in common parlance in ways that are quite different. So we're going to have a talk at the end about law students and debating in front of non-law students and not confusing the hell out of them, and also about non-law students and finding ways to deal with that jargon and engage in that knowledge. So we'll start with the basics. I want to start off with some reading, actually, and some suggestions for places you can go for further material. And as you move further on into debating careers, this becomes more important. The book I've got up on there on the screen is absolutely excellent. It's by a former UK, I think, Supreme Court judge. The guy really knows what he's talking about. It's a really quick tour of basic criminal justice principles and ideas about how the law should operate. And a lot of the things I'm going to talk about today are reflected in that book in a lot more detail. But if you want to learn about more topical issues in the law and more specific issues, I'd really recommend some of the US magazines. And by magazines, I don't mean like Dolly. By magazines, I mean some of the quite high-profile ones. So things like the New Yorker, things like the Atlantic, run quite frequent, in-depth articles about aspects of the criminal justice system in the US. So things like the death penalty, things like mandatory minimum sentences. Things like gun control. There's a really excellent article in the Atlantic at the moment about ways that gun control should be being dealt with and the ways that it influences criminal behavior. There's often some really in-depth material in these places. It's really worth looking for them. The two I've got up on the board are probably the ones that do the most and the most interesting stuff. You can come and have a chat to me or any other old people if you want ideas for where to do reading. And that's really quickly as well. Talk about common topics, and I want to break these down into areas more than I want to give an example within any of them, because they'll highlight to you the kind of common themes within them. And so much of debating and first principles, which is really what this presentation is about recognizing common themes and applying them to different things. So then the first big area of topics you'll get are reforms to the judicial process. So where it's not even about what is illegal or how you treat someone once you find them guilty, it's just about the process you go about to get there. And this is where you deal with a lot of principles of accountability and efficiency, and people are often quite bad at applying those. So we're going to have a bit of a talk about those later in the session. You might also have debates about reforms to penalty systems. So we've found someone guilty, they've been through the process, now what do we do with them? And finally, you'll have topics which are probably the ones you're most familiar with because they get set in DAV and similar comps really frequently. Topics about changes in criminality. So this thing is currently legal, we want to make it illegal, or vice versa. And you're dealing with basic role of government arguments. We're going to do a quick tour of all of these. But I want to start by having a bit of a focus on the roles of actors within the criminal justice system and the roles that they maybe play in influencing it. So this is where we'll get interactive for a moment. What I want from you is ideas about the ways in which each of those 6 actors I have up on the board can influence the way the criminal justice system operates and what points, particularly points of discretion they have in choosing to exercise their power. So to start with the legislature, what do they do in relation to the criminal justice system?
Decide on criminality, what's legal and
Absolutely. What else do they do?
Approve the appointment of judges.
Yep, so in many jurisdictions, they're in control of the appointment of judges. Anything else? Yeah, and it's broader than that as well. So it's not just that they set minimum sentence guidelines, it's that they set the procedures for how you apply the law to someone. So you might say all drugs are illegal, but you might also have rules about how much by way of an illegal substance you have to have on you in order to be amenable to that law. There might be rules about what particular sentences apply, whether you get a more serious charge if you have more than a certain amount of that substance. And so the legislature sets those, and there are a lot of things it can do that make a difference. You want to give me probably the most famous example of legislatures influencing the way sentencing carries out? There's a really good example from drug policy in the US. Anyone know anything about the difference between crack cocaine and powder cocaine in the US? Yep.
Crack cocaine is predominantly used by black people and powder cocaine predominantly by white people, and there are vastly different mandatory minimums.
Absolutely, although they've just been abolished, but for a really long time, the law adopted an actively discriminatory policy in how it dealt with what was essentially the same drug. And the effect of that was that there are a lot more African Americans in jail for cocaine use than there are a proportion of the population using that cocaine, because people who were arrested with powder cocaine tended to be rich young white kids or lawyers and people like that who were predominantly white and predominantly wealthy, and the sentencing guidelines for them and the procedures that were put in place around treatment of possession of that drug were vastly different. So you can see how the legislature, in not even just deciding what is illegal, but the way in which it's illegal, could have a huge impact on society. What about the police? What do they do in relation to the criminal justice system? Yep, how do they do that? They make arrests. Yep, what else do they do? Yeah, so they're just present, and that might deter people in a significant way. If you arrest someone, what are you going to do next?
Investigate them.
Yeah, so they do investigations, sometimes before they arrest people. We kind of hope mostly before they arrest people. But in order to do anything with that arrest, you need to have a certain amount of evidence, and we put police pretty firmly in control of that. What problems might that create in terms of the way in which they exercise that power?
They might be inconsistent, so they might say stop risk laws, they might stop black people a whole lot more often than other racial.
Subject of a really interesting court case in New York at the moment. Or similarly, there used to be a joke that particularly in the south of the US, there was an offence that was pretty much driving while black, that black people were far more likely to be pulled over for minor speed violations or a tail light being out, and they were therefore far more likely to be arrested for those kind of driving offences than white people were, because police looked at someone who was black in that car and decided to be racist. So there's obviously a quite big influence that police can have over that aspect of it as well. What about prosecutors? What do they do that's really important? Part of it's just in the name. They prosecute. And that's really important, because obviously if they're incompetent, then it doesn't matter how good everyone else in the system is, chances are those people are going to be released. But before they even get into court, there's a really important decision that they make, which is...
They have discretion over who to prosecute.
Absolutely. So again, you're African American who's been pulled over for a driving offence and they found marijuana in the car and the police goes to the prosecutor. Whether or not they're treated the same as the rich white kid who was pulled over in a different part of the state where it was more wealthy, that creates issues for how the law plays out and who's affected by the law. So it's really important to just be aware that these are all discretionary points in which we might have concerns about accountability, but we might also have topics about the way that we do, or the way that we deal with those particular individuals who are actors within the system. So you might get a topic about electing prosecutors, and kind of the obvious arguments are like, we want them to be accountable to the people, they're serving a public function, we should be able to control them. But the more detailed and more nuanced and more important material is why we want them to be that. And that's where if you think about the type of discretions that they can use, then you'll come very quickly to the kind of examples of where things can go wrong. And that's how you build a case. Because you can probably intuit if someone says to you, as Nathan did, the prosecutor decides whether or not they prosecute at all, you can intuit that there can be abuses of that power. And you can probably guess what some of those abuses might look like. And you can move fairly quickly from there to a case about discrimination in the south of the US. What about judges? What things do they do and what discretions do they have?
Well, they decide the outcome of some court cases.
Yep, so some court cases are decided directly by a judge. and sentencing, which is the other really important one. What else can they do? So before it even gets to the end of a trial and there's a decision, what else might they do in the interim? Yep.
They decide what evidence is admissible.
They decide what evidence is admissible, yep.
Interpretation of the law.
Yes, they often instruct, if there's a jury, they instruct the jury as to what things they're allowed to find, you know, what range of options are open to them because of the interpretation of the law, or they might themselves adopt interpretations of the law. There's one final thing that they do that's probably really important. They might dismiss the case entirely. So it might be in front of a jury and the judge might say, look, presented so much evidence so far, I've got an application from the defendant that there's no case to answer, I agree. On the evidence that is before me, it would not be possible for a reasonable jury to convict, case dismissed.
On that,
Yep.
is there a difference between dismissing a case and directing a verdict?
So here we get a little bit technical. Directing a verdict kind of has more to do with the judge stepping in and being like, well, depends on your jurisdiction. So in some jurisdictions, the judge might come in after a verdict's been found and say that verdict was impermissible on the facts available to the jury, and I will therefore step in and deliver a verdict irrespective of what the jury has found. There are some situations where they might preempt it and choose to dismiss a jury, but generally the right to have your case heard by a jury is strong enough that it's quite difficult for a judge to get rid of a jury entirely if one of the parties to the case wants it. This probably gets a little bit too technical. It's worth having a chat to people maybe more one-on-one. You're unlikely to get a topic about it because it is quite technical and because it does vary quite widely from jurisdiction to jurisdiction. So particularly for international tournaments, I wouldn't be worried about it. Juries, what do they do? Yep. Decide guilt or innocence. In a more technical sense, finding a fact. So juries are, again, quite restricted in what they do. That's not to say there aren't circumstances in which that's different. So in some cases, a jury might actually decide what the sentence is. And if you're looking at the US, in most states, the jury decides whether or not the death penalty is the penalty that's given to the defendant. Yep.
Just two things, because you've actually just reminded me of something.
Yep.
One of the arguments against the death penalty is that the judges have been able to set so many hoops that have to be jumped through for it to be imposed that it's become totally impractical to ever enforce. So that's some piece of things that judges can
Yep.
do to change laws. But just also in juries, in some jurisdictions, jury nullification is something that can be argued. So that's another.
Yeah. So jury nullification is kind of the thing I was talking about earlier, where you're like, well, the jury's made this decision, but we actually think that decision is illegitimate on the facts, and we will nullify the jury. There are also some quite complicated things where new evidence becomes available, and you might vacate a decision, and that frequently happens in cases of exoneration of death penalty cases, where the way it's resolved is all parties to the case coming forward and saying, look, we've looked at the evidence, and it's just factually not true that this person committed this crime, and we want to void the verdict. Again, you're getting a little bit complicated in terms of the stuff that might actually come up in a debate. It's worth reading about it, and certainly if you're interested in it, I'd recommend doing that, and I can point you towards some resources, but I wouldn't expect there to be a topic explicitly about it. Finally, parole boards, and this is one most people forget when they're talking about prosecution and criminal justice, though it's particularly topical in Victoria at the moment. What might a parole board do that changes the way the criminal justice system operates? So if you're sentenced to 20 years, do you serve 20 years in jail definitively? No. So there's obvious, why don't you do that?
Because it's common practice for most people to serve at the last period of their sentence under parole, which is a system where there are restrictions on your movement. Say, for instance, quite commonly, if you've got a curfew, you can't drink alcohol, things like that. You are still technically serving your sentence, but you are otherwise in the community.
Yep.
Do you want me to say more?
No, that's probably what I want from it. Why might that be an issue in terms of discretion? Let's maybe take an example. Think back to some of the racism stuff we were talking about earlier. Why might that be an issue?
Well, if you have a racist parole board, you're unlikely to see certain percentages of people actually getting parole.
Yep.
But also, if you had a racist judge who imposed the sentence, there is the ability for that person to be released early if the parole board sees this person is not a danger to the society.
I mean, similarly, some jurisdictions will also let senior members of government exonerate people. Even if there's a guilty verdict, they can come in and give clemency and have them released. But the other thing that parole boards might do, they might not even be actively racist. How would a parole board assess whether someone is safe to be released into the community, which is kind of the assessment that they're doing? Yep.
Based on the reports of the warden of the prison and the guards.
Yep, so reports of wardens, guards, judges' recommendations, past convictions, how that...
If they've got job prospects, a home to go to,
Yep.
things like that.
support in the community, how that person presents in person. Are they articulate? Do they sound like they have remorse? What happens when you've got someone who's quite poorly educated? They're likely to fulfill fairly few of those things. If someone has very little support in the community, very little of those things are going to be fulfilled for them. If they've grown up in a very disrupted background, chances are they have lots of minor convictions. That doesn't play well in front of a parole board, but that also leads into a whole bunch of sentencing patterns and parole patterns that have quite racial biases, and potentially quite gender biases and quite class-influenced biases. So being aware of those factors playing into parole boards' decisions, because it probably is the most subjective part of the criminal justice system, is really important. And that's not just because sometimes we release people who are really dangerous and that's really problematic. It's also because sometimes we don't release people, and that's really problematic as well. So it's worth being aware of these actors. It's worth thinking about what discretions they have and the ways in which they're able to act. It's worth thinking about what things they have control over. And all of that will help you determine how best to approach those actors in talking about the debate. All right, so let's talk about some of the underlying clashes of principles that you might deal with in a criminal justice debate. So obviously there are some clashes about the aims of the criminal justice system and what they should be and how you prioritize them. But there are also a bunch of ones that come up a little less frequently that are worth knowing about. So we're going to have a bit of a talk about accountability and efficiency. We'll talk in slightly more general terms about public participation and versus expertise. So would we prefer to have a jury that's got, that's perhaps more strongly representative of the public, or would we prefer to have a panel of experts that has a greater understanding and knowledge of the unique circumstances of that particular case? How do we compare the needs of the victim with the needs of the accused, with the needs of society? Where do we prioritize those? Because they're all individuals and all people with rights. Do you just pick one? How do you just pick one? And if you don't just pick one, how do you balance those rights in between them? And also what the appropriate role of sanctions are. And we'll talk about all of these in varying degrees of detail. Let's start with the aims of the criminal justice system. And I want to start with this slide because people often just forget this in debater land. We go so far down the rabbit hole that we just talk about philosophy a lot. It's worth noting that at the most basic level, the role of the criminal justice system is to prevent crime and make society safe. It's not really much more complicated than that. The things that we do around that are driven by a whole range of ethical considerations and practical considerations that we take into account when determining how best to fulfill those aims. But it's worth not getting too technical, at least in terms of how you think about the debate, if not in terms of how you argue it. That will let you be a lot more grounded, a lot more realistic, and probably a lot more convincing. But that's because we're debaters and we've got to be realistic about the type of things you've actually got to argue. Let's talk about this on a more principled level. So I've got up on the screen kind of the four main roles of the criminal justice system, or the four main aims of it. Does someone want to give me a quick definition of punishment and retribution as it relates to the criminal justice system? Here's someone I haven't heard from a bit. Yep. Yeah, so they've done wrong. They deserve some kind of punishment for that. And victims deserve the knowledge that they've received retribution. The person who's harmed them has been punished or penalised for that. And so in some ways, this is kind of driven by like basic, schoolyard. They did this. They deserve to hurt for it mentality. But on the flip side, it's also driven by we need to engage victims and make them feel comfortable in the system and comfortable in society. And this is part of doing that. What about protection of society? What are we doing when we're trying to do that? Why is it a role of the criminal justice system?
Simply, like, if people are dangerous or a threat to other people in society, just keep your punishment society going in a way of getting them out of the punishment society.
We know that this person is a violent rapist and murderer. We are pretty certain he'll do it again if he's out in public. We probably don't want him out in public. Fairly simple, basic steps. What about deterrence? Absolutely. And rehabilitation? Yep.
Trying to make sure that we don't see these kind of people in the criminal justice system again.
Yep, absolutely. We want to have them go through it once and then never commit a crime again, so we never have to deal with them again. But there's also something that I think, so the first thing I'll say about all four of those things is those of you who are law students will learn about aims of the criminal justice system in relation to the Sentencing Act when you do crim law, and there's a much longer list. This distills it down and is the usual debater list. It doesn't mean that you might not use some of those other aims, but they are generally thought to be sufficiently either covered by these 4 things or sufficiently esoteric that I'm not going to run through them. And I don't think anyone misses out on anything by not knowing about them. But it's worth just being aware when you study things like CREM that sometimes the things that you talk about are driven from a very different and more legalistic perspective than the perhaps more policy focus that debating tends to take. So I want to then talk a little bit about proportionality, though, because obviously someone commits a crime and we say, okay, well, they deserve to be punished for that. How do we restrict that punishment? Should there be upper boundaries on how far we go? If it would be a really effective deterrent to chop the left hand off everyone caught stealing, would it be okay to do it just because it's a really effective deterrent? No. No, why not?
Because losing your hand is significantly worse than than the society bad for stealing something.
Yep, absolutely. Which comes back to the thing I spoke about earlier about balancing victims against other actors that might be involved. So, yeah, sure, we want to protect society, but also that criminal, even if they are a criminal, has a set of rights that we might think are important. And we'll talk a little bit about rights-based analysis later on. But the real point I want you to take out of those 4 things is you can't have them all and you have to balance. So in terms of balancing it, if we say, I want you to do a debate about mandatory minimum sentences, how do these 4 aims of the criminal justice system play into that? Which ones do you think would be well favoured by the government side? Which ones do you think would be well favoured by the opposition? Yep.
Government gets protection of society and deterrence, I think, quite strongly.
Yep, why is that?
Because the vastly larger punishments deters people because it changes their calculus more, and protection because they're physically removed from society.
Yep.
In terms of punishment and retribution, there's probably a good argument that that those sorts of things need to be very closely tied to proportionality, and it's much harder to do that. In terms of rehabilitation, the alienation from society that comes from mandatory minimums would likely lead to that being worse. So.
Yep. And you can probably imagine, just looking at the idea of a topic about mandatory minimum sentences, that in most debates your opposition is likely to focus on rehabilitation. It's going to be quite difficult for them to argue that giving people a mandatory minimum sentence won't at least increase the punishment level for some people, and that therefore that might not be a quite good thing for punishment. What they'll end up doing is running arguments about how you balance those factors against each other and why rehabilitation might be far more important in that particular debate. And you can do similar things with things like the death penalty or with perhaps community-based orders and saying we should never, for instance, if I gave you a topic about never sending non-violent offenders to jail, you'd have a very different view of each of those factors up there. So you would probably say that that would quite reduce punishment and retribution and perhaps have issues in terms of protection of society or deterrence, but could be very good for rehabilitation. And we'll talk a bit about deterrence later as well. In fact, we'll talk about it now, because deterrence is a little bit different. And so there's a couple of things I want to say about this that are really basic and that kind of come up pretty regularly, and most of you will have heard them before if you've done criminal law debates about the criminal justice system, which is that deterrence as a concept relies on offenders being quite rational. So it relies on a quite strong calculus of risk versus reward, where people sit down and are like, if I commit this crime, I will get X amount of money, but if I am caught, I will get X amount of punishment. The odds are in my favour in this particular way, and therefore I'll commit the crime. And if we just added a little bit more to the fine, then they wouldn't do it. In reality, most crimes aren't that well calculated. They're either crimes of passion, and people aren't thinking at all, or they're crimes where the individuals involved kind of lack the knowledge and education to understand the deterrence or to even know what the particular deterrent factors are, and therefore are perhaps unlikely to be directly deterred by the exact amount of the punishment that would be afforded to them, and also by people feeling like they'll get away with it. And it's kind of the same thing that leads to people buying lottery tickets. Everyone always thinks they're the lucky one. They're the one who's going to have the reward. And in a similar way, people who commit crimes generally think they're the lucky ones who'll get away with it. They think that they've thought of everything, because if they could think of a reason why they'd get caught, they would fix that thing or not do it. So they think they've covered all their bases, they think they're safe, they think they're therefore quite likely to get away with the crime, and they're therefore likely to commit it. And it means making arguments about deterrence is actually quite difficult, and you need to step through the arguments about why penalties have an effect on people's decision-making calculus. So I want to take a moment to do that as a group and talk about it. But before we do that, I want to throw out on a couple of other things that I think perhaps, well, particularly one other thing that I think perhaps should come up more often in these debates, which is that higher penalties can incentivize worse crimes. And I've got an example up there in terms of rape and murder. And there's a reason that most places that have the death penalty only apply it to murder. And rape is a good way to illustrate the example for why that is. If you get the death penalty for rape, what's the incentive not to murder the victim as well? Pretty low? Yeah, it's basically just relying on your moral code, which presumably isn't that strong because you're a rapist. But on the flip side, there's actually quite a good incentive to do it, to kill that person. What's that incentive? Yeah, they're a witness. If you kill them, you're far more likely to get away with it. So if you're really raising the penalties for a certain type of crime, think about the other crimes that person might be then incentivized to commit, because the penalty wouldn't be any worse than what they would otherwise receive. And this is really important when it comes to things like mandatory minimum sentences, where if you raise the penalty for things like petty theft high enough, then people start doing more elaborate things because the extra penalty for armed robbery isn't much higher, and you're less likely to be recognized if you're wearing a ski mask. But it's a bit hard to shoplift if you're wearing a ski mask. So you incentivize people to do things that are perhaps more drastic because the penalties for them aren't any different, and the chances of getting away with it are higher. But let's talk about how deterrence might actually work for a moment. So anyone have any ideas about how you'd make those arguments? I give you a debate and say, we're going to introduce the death penalty. You're going to reintroduce it. You're the government side. You want to make an argument about the death penalty. How do you do it? Yep.
Well, in terms of deterrence, I'd say something like, we want murder to be held by our society as the utmost wrong it is possible to do. For the psychological blocks for people to do that to be so harsh that people are less likely to do that, even in the case where they are irrational. It is going to be harder for them to commit that action because society holds it as a much more taboo action by saying that it is worthy of the utmost punishment, which is the death penalty. So that's how you weigh it around.
Now, how would you turn that into a generic argument? Because you're basically on the right track. If I wanted to boil it down so I could use it for pretty much any increase in penalty, what would be the basic bones of that argument, that structure?
You're creating a culture where that crime is reprehensible with a certain amount.
Yep. And so even if the individual potential criminal doesn't understand or know what that penalty is, you've created a certain social norm around it, and that itself is a deterrent. And then you can also run arguments to say, in fact, the people who commit this particular type of crime are very heavily influenced by risk versus reward. Can anyone think of some examples where that might be really, yep?
A couple of debates that we did during before I stood Mises was using deterrence as a good argument for white-collar crime.
Yep.
Because of the way in which it works, where it's not a kind of a heat of the moment kind of crime. They're often calculating things. It's often due to money, so they have to factor in certain things like that so they don't get away.
Absolutely. And I'd say drug crimes are probably really similar in terms of things like import of drugs. If you think the penalty is going to be much higher, there perhaps is a different incentive. There's also actually, and the Atlantic has a really interesting article written by a guy who's in jail for about 28 years for murder. It's a great article. I'd really recommend people looking it up, and I'll put it up on the screen at the end of the session. I'll find it again. About gun control in the US and the type of people deterrence affects. And his argument is basically that, in fact, most crimes that are committed with guns in the US are committed where the gun has been purchased legally in a state with really poor regulation about access to guns. It's been purchased legally by someone who's fairly vulnerable and therefore open to pressure, open to things like monetary pressure. So you go buy this gun for me and you'll get an extra 10% of the cost as a reward. Or open to manipulation because of drug addiction and things like that, who are sent in, purchase the guns, obviously clear background checks or any spurious check like that, and then immediately report the gun stolen, but in fact pass it on to the criminal who wants it. And what he argues is, in fact, deterrence is really important for those people. And it's not about the criminals at the end of the line who want the gun. It's about the people who facilitate that. And deterring those people is much easier because they're often much more driven by things like money. And also likely to be much more scared if the person behind the counter says, I've just looked at the report from this agency and you've purchased 3 guns in the last 3 months, care to explain? They're much more likely to walk out of the store. And so there are really interesting arguments that you can run about certain types of people and why deterrence might work against them in ways that you wouldn't expect it to, against someone who's maybe more committed to that crime or has a different background. And this is just kind of a summary slide of the things we've spoken about. The whole point of talking about the aims of the criminal justice system is not that any one of them is a universal good. The whole point of what we've done in the last 20 minutes or so is to show that they're not universal. You have to balance them against each other because pretty much no policy will maximize all of them. And so what you have to do is not just show the impact of your policy or the other side's policy on any given one of those aims, but explain why that particular aim is particularly important in this debate. Here's why we care about it. Here's what the impact would be. Here's why that impact is bigger than any impact they can claim. And it's really important to do that second step because that's actually what wins the debate, not how strong you can prove the deterrent effect of your policy might happen to be. Okay, so let's talk about some rights theory. Very exciting. Criminals obviously have certain rights taken away from them. I don't think that's going to come as a surprise to anyone. There's a pretty broad range of rights we take away from them. You could add up onto the ones on the screen also often financial rights. We take away money from them. We might impose other conditions on them, so we might do things like track them. So that might be an imposition on their right to privacy. But so basically we take away a lot of rights. We also, though, recognize and afford them a bunch of protections, particularly natural justice rights. And freedom from torture is not a natural justice right, and that should not be indented. But we take away certain rights, but we preserve others. There's obviously a calculus going on behind that decision. And knowing that is going to be really important to debates that you do, particularly if you get some of the old chestnut topics about things like allowing torture of certain types of criminals, then you're going to need to justify why you want to adopt that move away from what is kind of a pretty strong trend or norm. So, why are we able to take away rights from criminals at all? Let's start there. Yep.
The general theory is that you have violated certain rights by not keeping society safe, doing like dangerous kind of things, and as a result, the things that we're going to take away from you are proportional to the things that you've done.
Yep, and that's kind of a potted argument, basically, about social contract theory. So basically we say the reason that we afford certain rights and protections but are able to take away certain others is that there's a social contract. Everyone in society gives up certain rights in return for having a government that protects them. And so that might include some things like rights to privacy. Your police force can get warrants and search your property, and that's a violation of your right to privacy, but it's also something that we as a society accept, possibly because of a social contract. Similarly, we might say, you give up certain rights to freedom, and that might be even if you're innocent. You might be arrested for a crime, detained in custody for 2 years, finally tried, found innocent. We don't compensate you. We don't give you any kind of recognition for the time that you spent in jail. We just say, oh, you're not guilty and you can go now. And the reason that we accept that as a society is plausibly a social contract theory. That's not the only answer. We're delving into the realms of ethics and philosophy, and there aren't single answers. There's a great deal of debate by people who know a lot more about this than I do about what one of those is the most accurate in terms of reflecting the way that we should set up a society. But that's one way you can approach it. The other way, which is the way I've got up on the screen, is a rights balance. So to say there are lots of different rights. We can't fulfill all of them at once. So we're going to have to try and balance them. What are some rights that we might be balancing? Let's say I want to lock up a criminal. What rights am I balancing? Yep. Yep, and what particular society's right? In terms of society's rights, what ones in particular might we be talking about? Bodily autonomy. Yep. So really basic, principled rights that affect a great number of people in society, and that's the justification we use to take away this individual's right to freedom. On the other hand, what about the rights of the criminal? What are we talking about there that we need to balance? Yep. Freedom of movement, freedom of association. And these are things that are part of what lets people self-actualize and all of those funny little buzzwords that debaters hate but use a lot. But the reality is those funny little buzzwords are there because there are things that we generally tend to think are important, and there's probably a reason behind that. So you need to be willing to exercise that balance. And so again, if we came back to it, if I gave you the topic, this House believes that it is legitimate to use torture on those suspected of having knowledge of imminent crimes, so crimes that are about to be committed, what rights are you balancing? How would you start it if you're the AF? Yep.
We arrest somebody fairly high up in a drug cartel chain who knows that certain actions are going to be taken, certain shipments are going to be made, or certain assassinations of opposing drug cartels are going to happen. We need this information now to protect people. We are happy to say that the rights of those who are being protected are more important than the rights of somebody who is engaging in criminal activity and trying to cover it up.
There you go. And you might get more utilitarian as well, so you might say there are more rights that will be affected, and that knowledge will allow us to save more people and whatever harm we might cause to that individual. On the flip side, if you're the negative, how do you argue it? The opposition, you think that we should protect this person's rights and we shouldn't torture them? Say someone other than Andrew.
Well, you can take a number of different positions. The first would just be that torture is an inherently inhumane thing that should never be sanctioned.
Yep. So you can go quite absolutist in terms of it. What else might you be able to do?
That torture is ineffective, and there's a possibility, like you would probably introduce other harms first, but there's a possibility that it won't work, which
Yep.
then means all the other rights you're violated in the first place.
Absolutely. So you can push down the benefit.
There may be abuse of that kind of power, but things that may not have the ability to protect all the rights that was originally planned for.
Yeah, I mean, you're a police officer. You really want a confession out of this person, and you think it's plausible that there might be someone else at imminent risk. You feel like you can probably argue it. Maybe you try and beat a confession out of them while you're at it. So there's obviously a whole bunch of things that you'd try and balance. I think there's probably a middle ground between it's an absolute right and we'll just talk about the practicalities. I think there's probably also a lot of stuff in the middle of even if it's not an absolute right, here is why that right to bodily autonomy and right to safety from pain is particularly important. And therefore, even though there might be these benefits, those benefits won't be enough to outweigh it. But all of the things that you've spoken about are all part of that broader perspective where you try and build a multi-layered case that says, firstly, we should never ever do it for these reasons. Secondly, even if it was marginally permissible, it would be ineffective. Thirdly, here would be these abuses of power. And fourthly, here's why that right is sufficiently important that their marginal benefit isn't enough to tip it over. But you want to start thinking again about how you can layer those cases. The biggest thing I can tell you about criminal justice debates is that most of them are boring and narrow. And the more that you can layer your case and come up with different approaches to it and different ideas, the more likely it is that your adjudicator is A, awake at the end of your speech, B, remembers you at the end of the debate, and C, was excited by your speech and is therefore interested in giving you a high score. So think about layering cases. Think about not just one approach to an argument. Think about multiple. Obviously, I've got another note about proportionality here. I think it's worth noting that both of those theoretical approaches start to fall apart if you stretch them too far. At some point, they just start to crumble. So the death penalty for minor property crimes would protect a lot of rights, but would be pretty unjustifiable. I mean, similarly, even if it wasn't a rights balance, the perpetrators have breached a social contract if one exists, but it's a pretty extreme reaction to a breach of a social contract. Okay, so let's talk a little more broadly then about what should be a crime. And I think we spoke about universal rights versus cultural relativism. I think we mentioned it really briefly earlier. But what defines the limits of government action in terms of making something a crime? What things do they have a right to get involved in and tell you not to do? Yeah. No, go ahead.
Things that infringe other people's.
Yep. Absolutely. So that's kind of the classic liberalism approach to it that says as long as you're not hurting other people, you can do whatever you want to do. But what are some examples of things the government makes illegal that go beyond that? Anyone think of some examples? Oh, yeah.
Like the old laws against sodomy and
Yep.
sexual relations.
Absolutely. Prostitution, arguably. Absolutely. So a lot of drug laws are really directed towards protecting an individual. Things like polygamy are arguably directed towards stopping an individual taking actions. Yeah.
Suicide?
Yeah, suicide used to be a capital offence. If you failed, we did it for you.
Suicide was actually enforced on a couple of occasions.
There you go. But yeah, there's obviously quite a lot of interesting things that we've had as laws in the past. And we've obviously decided since then that those laws were inappropriate, but clearly people at the time thought they were. So questioning whether or not laws that we currently have in existence might meet that same test, might in the future be things that we look at and say it was atrocious that we had laws against theft. Don't know. We might change as a society that far, but the point is, if you adopt certain kind of principled approaches to behavior, then certain things that we adopt as laws that we prevent people from doing are perhaps quite large impositions on individuals' rights. Similarly, I mean, there are some big examples that come up that most people find fairly non-contentious, where like, we should probably have laws against female genital mutilation. Anyone here think that we shouldn't have laws against that? But for some people, it's a hugely culturally important thing that is quite definitive of their culture, that is something that individuals within that culture feel deprived of if we make it illegal, where people are willing to go to quite extreme lengths to access. What was that? But those individuals who are doing that might even be doing it to only hurt themselves, but we still make it illegal. And we step in and say your cultural norms and the things that you find important aren't acceptable. On the other hand, we let people have quite radical cosmetic surgery. Yep.
I guess you could also say we have male.
Absolutely. And we've clearly, as a society, decided that one of them is more acceptable than the other. And obviously there are questions of degree involved in that, and some female genital mutilation is pretty far down the extreme end and is fairly shocking. But the point is, we've made a moral judgment about people's culture. You can't really hide from that. That moral judgment might be legitimate, but you've got to question whether that's an appropriate grounding for a law. And if you're quite liberal, quite heavily libertarian, you would probably say we shouldn't have those laws. And it's worth being able to do that because I have seen debates done about legalizing female genital mutilation. I've seen debates done about criminalising adultery, which most people in this room would probably say would be vastly overstepping the government's role. But you've got to be able to think about what the philosophical justifications you'd adopt to that. So again, if I gave you debate about criminalising adultery, what positions would you adopt? What philosophical groundings would you use to do that? Yep.
The kind of connection between, like, during a relationship needs to be protected for the kind of protection of the social fabric, and if you allow adultery to ruin that.
Yep.
They've made a commitment to somebody, they've built this emotional connection, then they've decided to destroy it. They have harmed somebody, they should be punished for it.
Yep. And you'd probably also be quite morally conservative. You'd say there are particular moral norms that the government has a role to promote, and some of those should be promoted through laws. In the same way that we have laws against polygamy, or in the same way that we have laws against incest, because we've decided that those things are inappropriate and unacceptable, and in a similar way we're going to decide that this thing is. That's not to say that that was a good topic or that anyone should ever said it again. Okay, now we're going to talk about procedural things, which is really exciting. And I'm not actually joking, because I actually think it really is quite exciting. It's often done quite poorly. So there's kind of, I think, just a couple of examples I want to step through in terms of doing this. The first of those is about electing actors, and I don't mean people in movies, though perhaps that would lead to some better casting decisions occasionally. I'm sure that... What was that? I'm padding time, Sam. I'm padding time. No, this is all really interesting material that I'm very happy to share. Obviously, in terms of electing actors, what I mean is electing judges. What I mean is electing prosecutors, perhaps electing senior police officers. All of these are things that are done in some places. So what I would say here is that the arguments for and against them actually generally don't change. And the reason that often these debates become quite boring is because you are doing the same debate over and over again, and all you are really talking about is kind of two big questions. The first of them is about what incentives you create for those particular actors when you elect them versus when you don't. So if I was to ask you, what behaviour do you think you incentivize in judges by electing them every 4 years, and you were arguing for doing that, what would you say? What behaviour would you say was incentivized? Yep.
Use exercising discretion in a way that's explainable to the public.
Yep. So it holds them accountable. That's a good thing. What about more specifically? What kinds of things do you think they would do?
More majoritarian interpretations of the Constitution, even though it's there to protect individual rights most of the time?
Yep, so they would maybe pander to the majority more. You're the affirmative and you're arguing that we should do this. How would you frame that to make it sound like a good thing? Absolutely. And this is the law. It's supposed to reflect social norms. If society thinks that something shouldn't be criminal, then judges should interpret the law in line with that. If society thinks that a particular crime is very reprehensible, then judges should act in line with that belief. Because otherwise, it's not really a democracy. What other incentives might you create? Yep.
Like towards the end of that judge's time, when they don't truly get elected again, to have potentially more judicial activism in that way. Like if you elect them for a certain time period, there's a time in which they're like, I'm not going to elect the next term, I'm going to start making decisions that reflect this particular view of mine.
Okay. I mean, that probably exists under the status quo where they're elected for life, where they're appointed generally for life. But the other thing you've got to think about is, remember, always think about the perspective. So if you're arguing this from the app, you probably don't really want to stand up and say they'll become really active and do things they wouldn't otherwise do. You want to say this will free them from certain restrictions, and the way that you frame it is really important. Yep.
Perhaps more nuanced versions of the other arguments we've just been talking about is to compare that to the process of appointment right now. So to say it encourages them to explain their decisions and to make decisions in accordance with majoritarian view, as opposed to appeasing certain political actors who might otherwise control their appointments.
Absolutely. And what type of people are likely to be appointed as judges? Old white men. Also lawyers, right? They're people who've had a certain degree of privilege in their lives, who've probably been fairly well educated in high school, because they've gotten into law degrees in the first place, and there's a huge class divide in terms of who has access to it. And they've probably then been quite successful lawyers. They've probably then been quite isolated from certain portions of society as a result of being relatively successful. We don't generally appoint judges who are bad lawyers, so they're probably quite rich. And that means that they're a certain type of person. And they probably have certain norms and certain expectations from society that may not be representative. If they're beholden to an election, you change their behaviour in certain ways. Let's flip that. You're the neg. What incentives do you create for judges? Yep.
Like the flip side to the majority rules point about making majoritarian views, you may infringe on the rights of the individual.
Absolutely. It's really good that judges are isolated from majoritarianism because that means they aren't subject to populism. That's good. Yep.
Judges should be experts. They should know what they're talking about when it comes to criminality and the effects their sentencing will have on people and the likelihood of reoffence.
Absolutely. Yep.
Essentially that point, most people don't know much about what judges do and how they work.
Absolutely. So how do you decide who would be a good judge when you're going to go and vote? If you don't understand the law, we're going to talk about at the end of this some of the technical terms that get used very differently by lawyers compared to debaters or just general members of the public. How does a general member of the public assess? One of the things I will say, and I'll come to you in a moment, Tom, is that if you're writing a case for electing judges or electing any particular legal officer, any particular step in that legal process, I would really recommend spending a lot of time writing the model and getting it right. The last time I had to run this debate was writing it for some DAV kids I was coaching. We had like a 10-point model, and there's a reason for it. It's because you can actually shut out a lot of those problems. So you can say, for instance, we will require them to be lawyers, right? We want judges who actually kind of understand the law, at least on the most basic level. They must be admitted to the bar. Maybe for superior courts, we'll require them to have previously been elected to an inferior court. And you can probably justify those restrictions on the public's voting rights. I mean, you've got to kind of accept that you're restricting democracy by putting those things in. But by doing that, you probably cut out some arguments that hurt you more. So these kind of quite technical topics, the technical details can often be quite intuitive. And if you think there's an obvious argument against an aspect of your case, it's worth thinking about whether you can model that out without creating bigger problems for yourself. Yes?
Another thing for the next perhaps consider is arguably you want a certain amount of open-mindedness in a judge for them to be effective, but no one's ever going to be able to get elected if they aren't on a strong agenda.
Absolutely, and that's a really interesting point about the way the elections work. So all of these things are 100% equally applicable to a debate about prosecutors. You can probably also argue that they have a tendency to be old white men who are relatively well-educated and relatively privileged and are therefore divorced from society, and it would be good to elect them. The flip side, you can argue that that makes them exceptionally subject to popularism in the decisions about who they charge. And so you're going to run the exact same arguments. Yep?
And then you just kind of lead on by giving, like having elections, you give them an electoral mandate that people could shift from, and kind of undemocratic if they did during their however long their term was.
Absolutely. And so you have to be really careful about doing that. So the second thing that you talk about in terms of these kind of election debates is about what rights the public have to control the actions of people. So we're kind of talking, I spoke very briefly in terms of that first point about democratic rights. But if you're arguing for electing a certain stage in the criminal justice process, you're going to run a lot of arguments about democracy. You're going to run a lot of arguments about people having a right to control democratic action. If you're going to run those arguments, then there's probably a reason you're going to run them, but more importantly, you need to think about whether they're applicable to those particular actors in the criminal justice system. So let's talk about prosecutors. Let's maybe take the harder example. If you were the affirmative, the government team, what would you say about prosecutors and people's right to select them? Yep?
Communities have the right to determine how and in what ways specific crimes, especially things like prostitution, drug crimes and that, are prosecuted in their community, whether they are prosecuted to the full extent of the law, whether the prosecutor ignores certain minor crimes in order to get towards the people who are heading the cartels and to make those sorts of deals.
Absolutely. And the other thing you want to think about is we give prosecutors and we give police monopolies over certain types of force. I mean, you probably heard the phrase, the state has a monopoly on violence. The idea of a perfect democratic state is one in which state is the only actor that can be violent. But the idea behind that is that we give them certain rights to use on our behalf, and we're supposed to give up certain aspects of that. If you're giving up that power, perhaps you retain a right to control the way that it's used and the way that they exercise it. Because it is such a impositional force that they're given, they therefore perhaps have an obligation to be accountable to the people. On the flip side, you can argue that the public is often a vast, uninformed mass, and it's really good to have representative democracy intervening to filter out the crazy. And that as a result, we should trust everything to the mad exec and never have AGMs. But the point is, there are flip sides to it, but you should be aware that just about every debate about electing actors, you're firstly going to talk about the elections, and then you're going to talk about what the actors do afterwards. And those are really probably the only two big moving parts in those debates. And I'm sure you'll be able to think of lots of interesting things about gay people, but the big moving parts in the debate are those two things. And any additional arguments that you come up with on top of that will probably be good fodder for second speaker material. So knowing that lets you kind of jump ahead when it comes to putting out those arguments. So juries, I've just kind of got a list of good and bad things about them up on the screen. They are obviously frequently crazy. They are also perhaps more representative. Maybe crazy is a thing that should be represented. Debates about them tend to revolve around whether or not they are justifiably or unjustifiably crazy. The most important thing for you to think about when you're talking about juries is to think about why we ever had them in the first place. They obviously do some quite crazy things and frequently don't understand technicalities very well. That said, try reading US Supreme Court decisions about science, anything to do with patents. Clearly, that is not necessarily unique to juries. So just be quite aware that some of the things that we perhaps throw at juries are really just true of anyone without specialist expertise in the subject matter that's been handed to them and are perhaps correctable. It's also worth saying that in Australia it's hard to tell how well juries do because we can't interview them. Most of the data that we have about juries doing crazy stuff comes from the US because they let their juries be interviewed. It's worth being a little bit aware that some of this is quite speculative, and maybe it's just US people from America who are crazy. Maybe our juries are better. But you are going to have to grapple with the fact that the reality is the type of people who end up on juries are probably not rich, well-educated people, because those people either would never be put on a jury by a defense counsel, would just automatically be vetoed, or would have reasons why they would be able to get out of that and would be able to appeal to judges to let them go. In reality, there's a disproportionate representation of the unemployed. There's a disproportionate representation of the quite young or the very old. There's a disproportionate representation of those who are employed in quite low-skill trades. And the reason for that is because if you're a lawyer, you're not even eligible to be on a jury. If you're a doctor, you can usually get out of it. If you're an engineer, you can usually get out of it. If you turn up with if you turn up with a stack of English literature to read in the waiting room, they're absolutely not going to put you on the jury. So, like, it obviously skews juries towards certain types of people and means that you need to be aware that they may well be crazy people. That doesn't mean you can't defend them. It doesn't mean you can't argue for things that would reform that and make it better. It does just mean that teams that are arguing against juries, I think, probably have a bit of an advantage by the fact that juries are not as representative as we perhaps intended them to be as a society when we started using them. That said, there's some really good things about them. They give the law a moral code. The law should have a moral code. It shouldn't be immoral. They're perhaps less biased than judges. One of the really interesting things I think is worth saying about juries that's not on there is about the fact that judges become quite jaded. So if you watch dozens of cases about the same types of crimes and you see the same offenders come through and you see them with repeat offences stacked up a mile long, and you look at someone who's committed that crime for the first time and they're arguing that they're rehabilitated and will never commit it again and deeply regret it, you're perhaps less likely to believe that than the average member of the public because you've seen it all before. And so judges do have a tendency to become quite cynical as a result. It's worth just being aware of the fact that juries perhaps bring advantages that are maybe not necessarily apparent on the surface, but maybe being a crazy person who doesn't understand the law might be a very good thing. All right, public buy-in. It's kind of pretty much the last thing I want to finish on before we do a little bit of a chat about jargon and then have pizza. Criminal justice is obviously really dependent on reporting and cooperation. It makes public buy-in exceptionally important. It definitely plays into the balance of accountability versus efficiency. If you might be able to set a policy that is exceptionally accountable to a certain type, to the society as a broad whole, but as a result leaves victims feeling like the process is completely alienating, so no crimes are ever reported. You might be able to put in place a policy that is exceptionally efficient. So you get rid of juries and therefore your trials move much faster, but also no one in society trusts the criminal justice system and therefore they prefer to be vigilantes. And as a result, your very effective process is now totally meaningless because people don't have trust in the judicial system, don't report crimes into it, don't attempt to bring prosecutions. So often getting that efficiency balance, it's particularly the case when people argue for amping up efficiency, making the judicial process really efficient, just churning people through, it means often that people don't engage with the process. And you can obviously see really good examples of it in the case of rape prosecutions, where people very often withdraw them because they find the process alienating. And the things that we would need to do to make that process less alienating are exceptionally expensive and inefficient. And so getting that balance right is actually perhaps more difficult than people perhaps assume. All right, jargon. This is one of the things someone mentioned to me and I thought it was really important to talk about. Lots of words have lots of different meanings. One of them, I think law is probably one of the more irritating topic areas in that way, because so many debaters do it and assume that when they're in a room and doing a debate that other people in the room share their terminology, and as a result frequently use terms in highly technical ways that are not shared by other people in that room. The result of that is frequently debates that are a confusing mess in a way that pretty much no other area of debates are. And they shouldn't be, because in fact the concepts underlying it are supposed to be simple and understandable, because the whole point of the law is for it to be an accessible representation of public codes and morality and norms. If it's not that thing, it's broken. So you shouldn't need really technical terms to explain it. I understand, and I share the law student frustration that you may have a better vocab than some of the people in the room, but if your adjudicator doesn't share it, that's useless. And if the fellow teams in the room don't share it, they may well completely miss the point of your argument, and as a result, that might hurt you as well as hurting them. So there are a couple of examples up there on the board of things that get used a lot. Some of them are just Latin. As a general rule, I would recommend not speaking in dead languages. Mens rea and actus reus literally just mean kind of like the mental aspect of a crime and the physical aspect of a crime. So it's about intent, and it's about the thing that you actually do. So in order to murder someone, you need to not just kill them, but also have certain intents that are attached to that. So either the intent to kill them, recklessness as to that, all sorts of technical distinctions that you don't need to understand. So when a debater stands up in a debate and says, this particular crime that they want to introduce lacks the mens rea, all you need to say is, but it's still a crime, and stop talking in Latin. Please don't get bogged down or thrown by people using Latin. Try and work out what the probable meaning of that sentence is, and then tell them that they're arrogant assholes. The others up there are ones which are issues either because lawyers and people from a more legal background attach certain significance to them that is perhaps disproportionate. Retrospective laws are a really good example of that, where people with people who are studying law tend to be really against the idea of introducing a law that didn't exist prior to you introducing it. So to make something illegal that was not previously illegal and then apply it to people who had committed that behavior prior to it becoming a crime, lawyers get very, very angry about that, and it's totally against the rule of law. A lot of people in society are like, but the thing they were doing was really evil, and we just had forgotten to write it down, and we should totally send them to jail. This comes up a lot in the case of white-collar crimes, things like tax fraud, or just fraud in general, where we just miss a loophole because it's really complicated, and then people come along afterwards and are like, well, that totally shouldn't have been allowed. And a lot of people just say, well, let's just prosecute them anyway. We really don't care. Lawyers will get very grumpy about that. If you're a law student in a debate about introducing something retrospectively, you need to explain why you're grumpy about it. There are good reasons to be grumpy about it, but just incandescent outrage is not good enough. The top two up there in terms of negligence, recklessness, and intent, and in terms of duty of care, are things that probably have different meanings in the general public usage compared to in the legal usage. There are obviously plenty more examples of this. I'm really just using this slide to remind you to think carefully about the terms you use. But negligence is a concept that has exceptionally detailed, 6 months of learning, concepts behind it. And law students will frequently use it expecting people to understand that inherently. Most people don't. Similarly, people will often use it quite casually and just be like, that behavior is totally negligent. And you're not really grasping the concept when you use the term in that way. Neither group doing that is right. The biggest point is terms like negligence or recklessness or intent shouldn't be used without some kind of definition, and I don't mean a dictionary definition. I mean an explanation of why you think that behavior is negligent, because otherwise you're just saying a word, and chances are everyone in the room has a different perspective on what that word means because it has a technical meaning and a general public use meaning. So please be really careful about those words. I didn't really want to put up a legal dictionary. I'm sure people have other examples. If anyone wants to share some that they've seen misused, that'd be great. Otherwise, we're going to finish, and I'm going to go grab pizza. Questions very welcome over a pizza break. Thank you, everyone, for listening to me. And please do email me if there's something you want someone to talk about. Or for that matter, if you're an old person and you'd like to do a training session because you think you have specialist expertise on something. There are some things that are on my list of things to get covered this semester that I really am not qualified to talk about.